Welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner. And with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, morning.
Morning, Mike. How are you?
I'm well, thank you.
Good.
Sam, today we're going to do something that may not at this time be really, really popular or affect as many people as it will in the near future, and that's electronic voting.
Yes.
So many of you that do read my fact sheets on our website, mbkchapman.com, go to the library tab, select fact sheets, and you can type in the search bar. Know that on January 1st, 2025, a new law went into effect. So basically a year and a month ago, a new law went into effect, and it's the electronic voting law that the part of the Davis-Sterling Act that applies to California HOAs. And a lot of HOAs haven't implemented it yet because it actually, they have to do some homework. They have to do some stuff beforehand in order to make it legal, and that takes time. It takes effort, and it takes it's a big sea change. It's a paradigm change. So we're expecting to see that to really start gearing up in 26, and then in the years to come, it'll be very commonplace.
Right.
So I'm hoping this episode will become a lot more topical in a year, but I wanted to get it out there anyway, because it technically has been the law for a year now, and there are HOAs in California that have implemented electronic voting. So that's what we're going to talk about today, okay? The law is not self-executing.
It's not.
In other words, there's no requirement that all HOAs now implement electronic voting.
They're not obligated. It's optional.
Completely optional.
There are templates for it in other states and other jurisdictions that folks can look into, but realistically, this will take several years to roll out.
It takes time. And we're going to tell you why it takes time. From the equipment and what the technology involved is supposed to be able to do, down to the actual amendment to election rules that are supposed to, or that have to happen to properly implement electronic voting in your particular HOA. Correct. So that's what we're going to talk about today, okay? Now, one of the big overarching truths here is that to implement electronic voting in HOA votes, I'll call them HOA elections, okay, the idea there and the requirement is that all of the secrecy requirements that have attached to paper ballots for time and all eternity still have to be honored.
Yes.
All right? There still has to be the securing of that secrecy, and the independence rules have to still be watched out for, right, or honored.
Right.
Okay, am I saying that right?
I think so. I think we get the gist of it. And the inspector of elections, really, I mean, you alluded to this in terms of the technology and so the way they would deploy or enhance their methodology to account for that secrecy and protections. That, too, is something that my sense is that they've already adopted that on the inspector of elections side, but I'm sure that there are things
that's probably easier
iterations where they need to work out some of the issues and glitches.
So the bottom line is that there can't be really any dispute that properly implemented electronic voting will make things faster. Certainly counts, It'll make things easier.
It can reduce costs.
It reduces costs. It reduces error.
Right.
Because theoretically, computers do that sort of thing better than humans do, and they aren't prone to the same error. Of course, though, we all know sometimes computers do funny things. So, but we're saying theoretically, okay? And so today we're going to kind of look at that whole as a big picture. We could probably do, and we probably will do in the future, a more specific episode, let's say, just on the technology, once we kind of know more. But today's going to be just a bird's eye view of electronic voting based on the HOAs that have or will be implementing the electronic voting rule that went into effect about a year ago, okay? So let's talk first with the big question, which is, what does this electronic voting law allow HOAs to do? What is it, okay? So the new electronic voting laws applies not only to elections of directors, but to elections relating to under Civil Code 4600, when
grant of exclusive use.
When common area is going to be switched to exclusive use common area.
Yeah.
That sort of thing. Okay, or amending a governing document, for example, the CC&Rs or the bylaws.
Exactly.
Okay, that would be permissible to use electronic voting for that. But the two things that are explicitly not exempted, but explicitly prohibited to be done by electronic voting, meaning you still have to use paper ballots for these two types of things, and you can't use electronic voting, are an increase over the limit that the board is authorized to do on their own of a general assessment or a special assessment.
Exactly.
So the implementation of a special assessment, so let's say it's over that 5% threshold, it has to go out to a vote for the membership. That has to appear on paper ballots still. And all the requirements that have always existed still exist. Or if they want to increase your regular dues beyond the 20% that they're allowed to do without the membership taking part in it, also has to be done by a vote and done by paper ballots. But everything else, including election of directors, can be done electronically, assuming that your HOA has implemented properly the procedures and has already amended their election rules to allow for that. Okay. And
just to clarify for the audience,
please.
The election rules, I mean, this is still subject to Civil Code 4360, notice requirements, the 28-day comment period, and that's sufficient for our purposes on this topic. They don't have to necessarily amend the underlying core governing documents, the bylaws, or the
election
CCNRs.
Rules.
So election
28-day notice period, done.
And that's rather quick and inexpensive. So the HOAs that are rolling this out and adopting this, or adopting it at least partially, they can go ahead and do this.
I think that was very good. I'm glad you made that point. It doesn't require this, it's in most HOAs, it's hard to amend CCNRs. Okay. This isn't that. This is pretty much the board making a decision, implementing a new rule, and then, went through the 28-day period, comment period. And if you're on the board and you're getting a lot of pushback from the members of your particular HOA that don't want it, then maybe you should listen. But if the board wanted to ignore the homeowners on that, and the homeowners didn't have the wherewithal to do a veto, the HOA could ignore, or the board could ignore the homeowners' comments and just go through the motions. But that's how easy it is, really.
Yeah.
Okay? So, good point.
But by the way, this just occurred to me. We haven't talked about this. One type of community or communities that I suspect may have a disproportionate opposition to this.
I don't think you should say it. I don't think you're going to say it anyway. Go ahead.
55 plus.
That's not fair. A lot of them are very tech savvy.
Okay. I didn't mean to be, profiling.
I knew he was going to say that, and we're going to get emails to that. I don't think that was nice.
Yeah.
Okay. I don't believe that's the case. Okay. In my opinion, my dad was, before he died at 87, he was doing day trading in his retirement on the computer.
The one thing I will say is senior communities, these 55 plus communities, that the membership engagement is amazing. I mean, they're
like 90%.
They're tuned in, they attend the meetings, and so they're very well informed. And when
a lot of these communities for the 55 and up, they rarely ever have a lack of a quorum.
Exactly.
Okay, that's true, by the way, in actual elections, for state elections and national elections. Actually, that's probably the most voting, participating segment of our society. Yeah. But we're digressing. Okay. All right, so what do HOAs have to do if they want to implement electronic voting? I'll start when we get to our list, and then I'll let you add some too, okay? Okay. So as I said at the beginning, this isn't something that's automatic. It's not required, okay? The board has to first adopt the election, operating rule, whether it's in their rules or their election rules. It doesn't matter where, whatever is relevant for their HOA, okay? And then they have to permit electronic voting through that rule change, okay? And this is done through, and it's got to honor, like I said, it's got to be secret. It can't be, all the secrecy requirements that exist on paper ballots have to translate electronically. In other words, the only people in the world that should ever be able to tell, whether it's paper or electronic, who you voted for is you and whoever you share that with. Yeah. Not the inspector, not the board, and no other members unless you tell them.
Right.
Okay? And that's under Civil Code 5105. So, rule adoption has to follow, I think you mentioned this, 4360 in the proper rule adoption, and that's great, okay? But to the extent that an HOA decides it wants to go in that direction and they want to adopt the rule, here's kind of what they got to do. There has to be a clear statement in the new rule. Yeah. In other words, a new rule has to make it clear that they are authorizing electronic secret balloting, Okay. And that electronic secret balloting has to be consistent with Civil Code 5105, which is part of the Davis-Sterling Act. Okay. What's another one?
Well, another one would be providing for clear parameters in terms of one member, one vote, essentially, or a vote per member or per home, I should say, for property. And that needs to be accounted for as well. So they don't have issues with multiple votes per homeowner. Yeah.
Okay. And the rule has to make it clear that every owner or any owner has a right to opt out.
Yes.
Okay. So your HOA could very well implement electronic voting, and you personally don't want to do it that way. You want the old-fashioned paper ballot and a double envelope system. You can opt out and vote through the paper ballot and mail it in to the inspector of elections like you've always done. The rule, when an HOA adopts electronic voting, their rules have to specify or has to be explicit about the fact that anybody has a right to opt out.
Yeah.
Okay, so it has to say you have a right to opt out, blah, blah, blah. Okay?
And just to add to that real quick, they can essentially go in one of two default voting methodologies, essentially, to use one word.
Okay.
One is the default can be electronic voting if they adopt that, obviously, and then you mentioned the opting out aspect of it. The other one would be that they retain the paper ballot, yet allow the default to be paper ballot and status quo essentially, and then allow for folks to opt in to an electronic voting dynamic.
And today we aren't gonna go any more than that.
Yeah.
And we're not gonna talk about or I'm not gonna spend too much time or even any time, we'll see, on the flip side, the part that you just gave, which is really the flip side of electronic voting. Mm-hmm. I'm not going to focus on whether or not paper or whether or not there has to be a meeting or not at that point, because we're only talking about electronic voting and with the opt-out today. Yeah. All right. Another one is that the rule has to remind everybody or mention everybody that we're still inspector of elections, and the inspector of elections will be the one receiving the tabulated electronic votes. Okay? And I don't know, technology-wise, because my HOA hasn't opted in for that. I don't know what that would look like because I've never received one of those yet. Yeah. So I've never seen one yet. And we haven't had any clients come in. We haven't had any disputes related to electronic voting since imposition of the new law a year ago. So I actually don't know what that would look like. Right. But that's what 5105 says.
And my guess is...
Or 5110, sorry.
My guess, other than it being encrypted and secure, and not allowing for, let's say, the vote cast to be traced back to a single identifiable individual
or property address,
for secrecy, right? Pursuant to the Davis-Sterling Act,
right?
That there would not be a universal system adopted by these inspector of elections. My sense is that there would be some variance between them. Right?
I'm not sure. I don't know the answer to that question. Again, this is new, and we haven't had the opportunity to meticulously challenge or go into this in the form of discovery in court, because we've had no cases that relate to a dispute regarding electronic voting. We might have had clients come in whose HOAs have implemented it, but it hasn't been an issue, so it hasn't come up.
The closest you can conceivably get to that is other jurisdiction, other states that have adopted this. But it's different.
I don't practice in other states personally. We do have MBK Chapman has an office in Florida, but I don't do the work there. We have Florida attorneys. Right. And I don't even know if Florida has that. That's not my purview. That's theirs. But again, the secrecy, that has to, the rules have to discuss the fact that secrecy is being honored the same way. There should be no way to tie back a vote. But also the policy has to allow for the fact that these votes are tabulated and kept for a period of time. Yep. Or under the control of the inspector of elections, just like paper ballots are. And the last one to remember is that the nominations and the timings for, when you submit candidates or how long between the submission and the election, and all those timings, those aren't changing either. They're not. Those stay the same. Okay. So let's talk about what we've kind of hinted at. There's obviously, if you implement electronic voting, there has to be methodology that provides the same level as you would in paper ballots of verification, security, and oversight. Mm-hmm. Okay, those cannot be sacrificed. So once you've authorized electronic voting in your HOA, the process is governed maybe electronically, right? But it's the same integrity standards.
Exactly.
Okay, that apply to paper ballots and always have. So under 5110, for example, just like in paper ballots, the inspector is responsible for verifying member eligibility. Okay, before votes are counted or announced, you got to verify whether or not the person's a member, for example, or and not a renter, or whether or not they are, let's say you have somebody running for director that would be otherwise excluded because you have a policy that says you can't run for a director unless you've lived there a year. You've got to, the inspector still has to verify that. Okay. The inspector or the electoral rules for electronic voting have to allow an inspector to confirm three things. One, the identity of every voter.
Yes.
Not necessarily how they voted in that particular occasion, but the identity of every voter, so they can decide whether or not the voter's a member, okay, or a renter or somebody else. To verify the secrecy of the ballot and to verify the ability to audit or reproduce the count if necessary.
Right.
Because you can't just have the computer go bling and
Some
then
form of receipt, but retained as part of their
somehow
ongoing records.
Right.
Yeah.
And I don't know the technology, folks. I don't yet have any information on that because I haven't seen one of these machines.
Yeah.
And I haven't had a chance to have to analyze one in the context of a case because we haven't had any yet. This is new. So under Civil Code 5115, the association still has to follow all those prescribed notices, right? The timelines for distribution of ballots, but electronic ballots, and paper if you've opted out, right? They got to still retain the voting materials for that year. They still have to do all that stuff. So in other words, I guess the takeaway here is no matter how modern the system becomes or has become, or the platform is, technologically speaking, it could be flashy with all these lights and whistles and all that stuff. It still has to permit that secrecy, neutrality,
100%.
Consecrating, the consecration of the vote.
The sanctity
That's what the word I
of
wanted.
the process needs to be preserved, and also there needs to be transparency. And my sense would be because of the tectonic shift for those who are transitioning to the electronic voting, for the membership to also be informed and educated about the process, right? And that directly also pertains to them being aware of their potential challenge rights under 5145, for instance, right?
Right, that still exists. You still have a year to challenge the results of an election.
Any facet of it runs afoul of the various procedures.
And as Sam pointed out earlier, this is very new to California, but there are other states that have had it longer and have a bit of a history. And boards that are interested in implementing electronic voting here probably have the benefit of not only institutions or groups in California that can advise boards, but also looking at how other states have done it. I'm sure there's publications to that effect. So we don't represent HOAs. That's not what our law firm is, exclusively homeowner-side. But I have a feeling that the HOA side law firms can direct their clients to resources that are true and time tested from other states. Because a technology that works in another state is going to work here too, even if it has to be tinkered a little bit to adjust for whatever minutia California might have that might differ from another state.
And by extension, my sense is that these HOA side attorneys and the boards that they advise will also heavily lean on these inspector of elections and these companies that will adopt these and work on these budgets.
Unless they're just using somebody in the community, like a lot of HOAs do for paper ballots, or using their management company. This might be a good time if your HOA, and it's not required, but if your HOA is about to or has implemented electronic voting or has passed that rule, maybe they don't use the management company anymore to act as inspector. Maybe they go and hire an actual company that one of its business services is inspector of elections, because they will have received training on this. And if they haven't, don't use them.
That's a great point, yeah.
But it wasn't always necessary before, and a lot of HOAs just use the manager or even a homeowner, right? Maybe you don't do that here because I wouldn't know how. I wouldn't want to be an inspector of elections for electronic voting. I'm not sure how it even works. I know how the paper system works because I've voted tons and tons in HOAs. I know how to do it. And we've seen thousands of them in the cases we've had over the years challenging elections. We've seen those. I've never seen an electronic voting tabulation report. I don't even know what it looks like or how it's formatted. Never seen one yet. Hasn't come up. Agreed. It will one day, but not yet. Okay, so let's let's be real practical here for you guys. We're going to give you kind of a checklist, a due diligence checklist for a homeowner, right? So if your association has been one of those ones that's decided to implement electronic voting, forward, technologically savvy HOA, okay? And that could include retirement communities, Mr. Sam. Here are some steps you should take to confirm that process is in compliance with this new law, okay? 1, you may have seen draft electronic voting rules during the 28-day comment period, right?
Yeah.
Theoretically, you're supposed to see that stuff.
Right.
But it's worth checking the final version and the board adopted, make sure it's the same one that was implemented.
Exactly.
Okay? Because you can't pass a rule without that 28-day comment period. And if the rule that was promulgated to everybody is not the same rule that exists on the 28th or after the 28th day, you got to start over.
And we've seen boards mess up. Where
Not in electronic voting, but in other things, yes.
On the adopted version, they
Right.
substantially modify it. And
what he's saying is we've seen situations where a rule was changed, but you looked at the, this after the hearing, the 28 days passes, and the hearing is now, or the new rule is now implemented, and you look at what was passed around during that comment period, and it's slightly different. Those are unenforceable. Yeah. Okay, so you don't want that to happen here.
Exactly. Yeah.
You can't do it with any rule.
Right.
But especially this is what we're talking about, right? You want to confirm that the independent inspector under 5110 has been appointed properly and that only the inspector has access to the data to confirm the results of the election. In other words, you can't have, let's say it's done through a login process. You can't have the boards having access to that login, right? It's got to be the inspector.
That's correct, yes.
Okay. And I don't even know what the technology would be to go in and manipulate votes, to be honest. I don't even know if that's possible. I don't understand this technology because I've never seen it.
I mean, I would hope that it's hack-proof and it can't be tampered with.
Me too.
Yeah.
And I'm going to assume that it is, okay? Yeah. Until I have a reason not to, I'm going to assume that it is. I don't have any reason to believe that the technology is not sufficiently secure that it should cause me to worry. I'm going to assume it's not that way until something comes up that causes me to change that assumption. Okay? Obviously, you want to verify notice and timing were all followed properly, just like a paper ballot, right?
Absolutely.
And you want to make sure that electronic distribution of ballots occurred in the same timeline that the paper ones did, assuming that anybody in your HOAs opted out and wanted paper ballots. And you want to obviously make sure for this particular election or for that election or that election, were people told specifically they had a right to opt out? Because you have to do that every time.
Yes. You
got to remind people every time you have a right to opt out. And that means, in other words, if you want a paper ballot, ask. And there's maybe a box you check or a button you press or something.
Right.
And then you get a paper ballot and you fill out the same way you always have, stick the little envelope in the big envelope, put it in the mail, pre-stamped, and boom, off to the inspector.
Right. And in other words, the notice aspect of it has to be
identical.
Identical, and it has to be for each election or vote cycle. It can't be a one-time thing and then you consider it done and not redo it on.
That's right. It has to work the same way every time.
Exactly.
Just like paper ballots do. You see the same thing over and over again.
Right.
Same small envelope, the same big envelope, the same instructions about check this box, put your name on the outside of big envelope, but don't write your name on the. It's all the same.
And by the way, for the electronic voting, when adopted and implemented, it has to be, each notice has to be custom to each individual homeowner. In other words, it cannot be some generalized, flooding mass mail. It has to be specifically addressed to each individual homeowner.
Yeah, but that goes with paper ballots.
Yes.
Too. So electronic voting doesn't come in the mail.
Correct. So in other words, it does not create an element where they can just simply disseminate one notice to the entire membership and deem that to be satisfactory or adequate. So even with electronic voting, they have to customize it to each individual member.
Now, see, I wasn't aware of that part.
No, that's a requirement.
Okay,
it's
great.
articulated
Yeah,
in the
good.
Yeah.
Okay. I mean, I obviously I read the statute before it. Once it was signed by the governor, I read it before it went into effect, and I've read it since. But again, we haven't had any.
I know.
We haven't had any cases.
Yeah.
And by the way, just let me explain why. We haven't had any cases on this because think about this. The earliest an HOA could have even contemplated having an election or a rule change would have been after January 1st, 2025. And most HOAs weren't ready to do that. So you're going to have some time there. It takes time to do that. And then let's assume they did that and things went wrong. There's a big process, probably 2 or 3 year time period where somebody is going to challenge it. It's going to go through some pre-litigation, attempt to work around, and then a lawsuit is filed, and then it has to get to trial, and then one of the parties, whoever loses that, has to appeal it and go to an appellate court. This takes a few years to do that. So the reason we don't have answers to a lot of these questions is because there's no court cases yet, that have on challenging any aspects of this new law. It hasn't had its chance to wend its way through our court system. And the only cases that are published cases that you cite, you don't do that with Superior Court cases. You do that with appellate court cases, which means it's gone to trial. Well, it takes 2 or 3 years. Let's say Orange County as an example, because that's where we're located. In the Orange County Superior Court, it could take 2 or 3 years to get to trial now, post-COVID. And so you're going to be beyond that to get to the appellate court and have the decision there. And if it's a published decision, then now we've got one, right?
And that's a true measure. Just to clarify one aspect of this for the audience, that's a true measure of
what the statute means.
The statute means and
that's
how
right.
it's interpreted and how the courts treat it. Now, in the interim, if you have minor disputes internally, or whether it's resolved by way of an IDR or some other confidential
or ADR
or some confidential resolution, that's not the true measure of it. That's by way of
what a statute actually says word-wise is very important. Don't get me wrong, but until a court has interpreted a statute, it's very hard to say what the law really is. Whether you agree with that or not, we're not commenting on that. I leave my personal opinions about politics and things silent. Hopefully, people don't even know where I stand on things, because that's the idea that I like. Other than I'm pro homeowner, for the most part, and I'm anti bad HOA and I'm pro good HOA, but I'm pro homeowner. Okay, so other than that, I really try not to announce where I stand on most issues, and so. I only say that to say that's just a reality of our system. Like it or not, that is how things work. Till the court has told you what a law means, it's hard to know what the law means. And in the absence of that court saying that, all you have is the language of the statute. Now, the more clear the language of the statute is, that is the less anybody could really interpret it differently, the better chance you have of being able to foresee what a court's going to say. Obviously, on parts that are kind of ambiguous, flip a coin versus, you must use a blue ribbon every time you do X, Y, and Z. That's hard to misread.
Right.
You can't argue, well, on some occasions you can use a red ribbon. No, you can't. Okay. I don't need a court to tell me that, but if there's ambiguity, that's when you need a court. And most laws are written with ambiguities because you can't, otherwise laws would be 1,000 pages each to account for every variation and, permutation. Yeah. So how do you challenge an illegal election? Well, fortunately, it's not that different than the current law. You still have 1 year from the election, okay? But if your HOA has run the election incorrectly, or there's some aspect of the electronic voting that was wrong, then under Civil Code 5145, you have a year to bring an action to invalidate the results or to challenge an aspect or to demand a recount, whatever the situation is, okay? Now, courts can, right, Sam? They can void election results.
They can.
In some cases, but they don't always do that.
They don't, no.
Okay? Sometimes a court will agree with you and say, this was wrong or this was a violation, but it wouldn't have made a difference. Something like that. They can do that. Right. Okay? That's not something you're going to be able to control. Okay?
And by the way, I don't know if it's worth mentioning, and perhaps you're getting to this next, is there's also a small claims avenue for these challenges.
I wasn't. So let's do that next anyway.
So that's still under 5145, which provides an avenue that if you're
Let's cover that separately.
Okay.
Let's cover that separately, because I wasn't going to talk about it, but it's a good point.
Might
we should.
Might as well.
Okay.
Yeah.
And I did address that. I don't remember if we addressed that in a prior podcast or if I did it in an article or fact sheet.
We had an episode on this.
We did?
Oh. Yeah.
Okay. I'm going to put a link to that episode. So if you want the episode where we discuss that in detail, go ahead and click the link that's above my my pointing finger there. I guess the long and the short of it when it comes to challenging the election is you're going to do it in the same timeline, the same way you would have with a paper ballot. Yes. That part's not changing.
Right.
Okay? What's changed is obviously this new element of this Fakachka computer somehow keeping track of all these votes and going where they're supposed to go and ensuring that person has access, can't see that George Meade at this address voted this way.
Yeah.
Necessarily.
Mm-hmm.
Okay.
Right.
Because if you think about it, and the inspector with paper ballots could do that illegally if they opened both envelopes and then paperclipped them together and then in secret looked at them. Yeah, I guess they could. So there might be a way for an inspector to break the law and do that here, because there has to be a way for that information to eventually come out if a court needed to know, but it's not supposed to.
Right.
Okay. Let's talk about that small claims thing just for a sec. And the reason I wanted to separate it is because what the law says you can do and what is maybe a good idea or what's workable in the real world are sometimes not the same. Here's what I mean. Well, do you want to tell them what I mean? Do you remember what I mean?
Well, let me briefly set the stage for
and then I'll fill
the
in.
Small Claims Avenue. So for what Mike was,
and then tell them what normally small claims. That's
what Mike was alluding to earlier is under 5145, Civil Code 5145, there's a special carve out for a judicial review of challenges to let's say violations or allegations of breaches of election procedures. Okay?
Election misconduct.
Election misconduct. It allows for essentially this narrowly tailored review by a small claims court, which typically is designed to address only monetary disputes.
Exactly. So let me stop you there.
And it's not set up for.
Let me stop you there. So
yeah.
That's one of the big things is that the way small claims court works is there aren't motions that you file in advance. You appear on the day of the hearing. They might try to get you to, talk with a settlement or mediator settlement before, but layperson number one presents their case, the plaintiff, and then the defendant, layperson number two, will present their defense. The judge usually takes under submission and then issues a decision later, and that's it. Okay? They don't have calendars the way that Superior Court judges have calendars where parties are coming in for different hearings throughout the pendency of a case. It's usually one off. You're there one time, and that's it. Judge decides. So small claims court isn't designed to, for example, issue injunctive relief. Injunctive relief is when a court orders a party to do something or to not do something. That's injunctive relief. It's very difficult or more difficult for a judge to do that because part and parcel with that power is what happens later if one of the parties ignores your order. You told them not to do X, Y, and Z, and they did it. In Superior Court, you make a motion to go into the court and you do a motion for contempt, let's say, okay? But in the small claims court, there's a mechanism to file motions like that. Yeah. Your judge was your judge for the trial. It's not like a judge for all purposes. And so it's not geared toward following up and being able to revisit prior orders. And yet the statute says you can go to the small claims court, not only for any money damages you might have, but also for injunctive relief,
correct,
right?
Yeah.
Related to election misconduct. That's what Sam was talking about.
And,
all right, go on.
And also small claims, there's a massive time constraint. I mean, it's kind of, the average, people's court to kind of get people in and
exactly
out.
What it is.
And these judge commissioners, presiding over these matters, I mean, they want to hear these matters within half an hour usually on average. You get a one shot at it, if that. And they don't have the time to kind of, meticulously sift through, the governing documents and your election rules.
They can't spend hours
and engage in what's tantamount to discovery. They're not going to do that. They're not set up for that. They're under-resourced, underfunded for those purposes.
Right. And they're over. They have, they have huge count. They have to run through 10, 15, 20 cases a day.
It's a volume-oriented, kind of a assembly line, so to speak.
And a lot of those judges aren't willing to do it.
Right.
And so here's what we were talking about when we said the law allows this as a potential remedy. And there might be small claims judges out there that take the challenge, and I have no problem with it.
Yeah.
But just because the law says you can do it doesn't mean it's always a good idea. In other words, we rarely will advise a client to go through the small claims if injunctive relief or something like that is necessary with respect to an election misconduct, because it's a crapshoot. Okay. Now, keep this in mind. Here's another unique thing, and I can't think of another example of this in the entire. Never mind the Davis-Sterling Act, in any of the corporations code either, or civil code. Correct me if I'm wrong. Can you think of another example of this? But in the case of a of a homeowner bringing a small claims case to the small claims court regarding election misconduct, to the extent that that homeowner met with an attorney, counseled with an attorney, paid an attorney to advise them, to maybe even ghostwrite their paper filings, write a brief for them, write an outline for them so that they could appear on their own at the small claims case prepared, they can actually get their attorney's fees as an award in the small claims court.
If they prevail, yeah.
I cannot think of any other situation and any other California law that I'm aware of where the statute says, oh, by the way, if you spent money on a lawyer in the small claims, you can get your attorney's fees back. The whole point of small claims is there's no attorney's fees. There's no attorneys.
I just recently, I want to say late last week, had a consultation on exactly that, 5145, where we told them that the consultation fee they paid with us on that issue,
they could seek that.
They could seek that. And they had a very, they came into it with this preference to attempt the small claims.
Which is fine.
And we gave them the pros and cons, and we gave them like exactly what we covered just now in terms of the limitations, and then that, if they kind of take a quick crack at it, and if it goes against them, then basically
that's that.
Yeah,
if you're the plaintiff and you lose the small claims, there's no appeal.
Right. So you mentioned that, but yeah, just to highlight the point you just made, that they would be within their rights to seek recovery of consultation fees.
Or let's say they paid us $3,500 to do all, prepare a trial brief, give us consult, tell us this and that, prepare an evidentiary outline for us, prepare our exhibit book, whatever. And $3,500, you can seek that as damages in small claims for attorneys. That is unheard of. I think I actually specifically discussed that in my book.
Nice.
Okay, when I was talking about election procedures in my book, HOA Hell, I have a whole section on that unique proposition. And to me, it's unique.
And I'm glad it exists, at least. It's a good option to have because it streamlines it and makes it, provides for an expedited review in cases where it's clear.
Right. And that's more likely to, we would be more likely to say you should use this avenue when it's a slam dunk type deal. Right. Okay, you're right. That's a great way to end on that. Small claims, even though it is sort of a crapshoot because of the nature of small claims judges and their calendars, in a really, really clear case, it might be a great idea. Okay. Or if there's no injunctive relief. Okay. But typically there is. Usually the whole reason you're there is because something was wrong with the election and you want it again. That requires an order. Orders can be disobeyed. You can't allow disobedience and have no remedy. So you're going to have to go back. That's why we're getting into it's this problem. And I don't know how to resolve it, but it's in the statute, and you can, if that's what you want to do, you can do it. Folks, let me close with this, okay? Electronic voting is the future, okay? It's in theory a fantastic idea, and if all the kinks can be removed and we can, if HOAs can properly introduce amend the election rules to allow for it, and it's done properly, and the proper security methodologies are all followed, it is probably a very efficient way to go. Oh, yeah. So time will tell how long it will take for the average HOA to have implemented electronic voting. But for the most part, most HOAs haven't done it yet. But it's probably coming. And when it comes, we welcome it. I mean, I like technology. I like relying on advancements in technology. And there's no doubt that this is going to be more efficient at some point. Presuming all the safety protocols are secured, it's more efficient. It's much less expensive. Just thinking about the savings on
less paper.
Yeah. Savings on the trees and savings on postage. If you've got a big HOA, that's a lot of money that you're paying for every election. That's all gone. So, or at least it's significantly reduced depending on how many opt-outs you have. But the point is, it's efficient, it's less expensive, and results will come more quickly. And so there's a net benefit, net positives to that. If you like this episode, please hit the like button. If you haven't already subscribed to our channel, please do so. If you have a question, want to leave a comment, you can do that anytime you'd like. And until next time, folks, have a wonderful day.